not just hearing things then.
I'm gonna mute him just so until we open this up. I'm muting people.
Works for me.
Mr. Carleo will unmute.
I think we're still waiting on 2 board members. Laura Spector Morgan and then Andrew, but he won't be sitting for the first 2 cases. So.
Which cases is Andrew?
He has a conflict with case 37-20 and 46-20.
All right, so we move 46-20 up to second.
Yes, yep. And Laura Scott will be sitting for both of those. Hello, Laura. I heard you.
Hello. Thanks for moving the cases up. I don't mind sitting, and waiting, but I appreciate it.
Now, there's important things going tonight, so. Nick's always in a hurry to get to a hockey game, but.
There's going to be a food fight on television, but that doesn't start till 9.
Right.
Okay, I guess I'm on now.
Okay, I just saw Andrew show up.
Laura Spector Morgan's in D.
Yep.
I'm going to move her over to panelist. There you go, Laura. You on board?
Yes, I'm sorry, I couldn't find the link.
No, you're good. Throw the hand up.
Can you guys hear me okay?
Yes.
Okay, I'm trying to get my video going, but I can see everyone else.
I think I've successfully unmuted myself. Chris, can you hear me? It's Jim Monahan.
Mr. Monahan, good to see you.
Can you hear Nick?
I can.
Thank you.
I can hear you and I can see you.
I'm going to have to get a pen. I'll be right back.
And I can see you going to get a pen.
Here, take mine.
Is there any candy in the drawer?
Cookies, there's cookies.
All of our cases this week are recessed, correct?
Correct. The one new case asked to be recessed till next month.
Okay. And the ones that are reset that are not being heard tonight are which one? 4720?
Yes, 47-20, and that 47-20 requested to be withdrawn.
Yep.
And 50-20 requested to be recessed to next month.
All right. We can take care of that in the beginning too.
Yeah, that'd be best.
Okay. So we'll be hearing 3720, then 4620, but before that we'll recess 5020.
I think you have it well in order.
Was that the lead-in music?
Yeah,
Yeah, we always have lead-in music.
that was me. Sorry about that.
We good to go?
Yes, we are, Chris.
Okay. Good evening, ladies and gentlemen. This is Christopher Carley, Chairman of the Concord Zoning Board of Adjustment. Welcome to the October meeting of the board. Due to the COVID-19 coronavirus crisis, we'll be conducting our meeting electronically rather than in person, as authorized by Governor Sununu's Emergency Order 12, pursuant to Executive Order 2020-04. The Governor's emergency order waives the usual legal requirement for a physical location at which the public can observe and listen contemporaneously to ZBA meetings. However, in accordance with the emergency order, the city is taking the following steps to provide for public participation in and access to the proceedings as fully as possible. We're required to provide public access to the meeting by telephone, with additional access possibilities by video or other electronic means. We are using the Zoom platform for this electronic meeting. All members of the board have the ability to communicate contemporaneously during this meeting through the Zoom platform, and the public has access to contemporaneously listen and, if necessary, participate in this meeting through dialing the following phone number: 929-205-6099. That's 929-205-6099. And that is outside the 603 area code, so you'll need to put a 1 in front of it if you are using a landline. And the password for the webinar is 610-919-318. That's 610-919-318. Or you can click on the following website address: us02web.zoom.us/610919318. That's us02web.zoom.us/j/610919318. We are also required to provide public notice of the necessary information for accessing the meeting. The city has given notice to the public of how to access the meeting using Zoom, and you can find detailed instructions on how to participate on the City of Concord's website at concordnh.gov/280/zoning-board-of-adjustment. We are also required to provide a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please call 603-856-3913. That's 603-856-3913, or email at code@concordnh.gov. If the public is unable to access the meeting, in the event that any member of the public is unable to access the meeting concerning a case or cases in which they have interest, please call 856-3913 or email code@concordnh.gov as soon as possible. We'll adjourn the hearing and reschedule it for a time that will allow all to participate. Please note that all votes that are taken during this meeting will be done by roll call vote. Let's start the meeting by taking a roll call of attendance. Mr. Wallner.
Nick Wallner, and I'm here all alone.
Okay. Mr. Monahan.
Jim Monahan, and I am alone in my home office.
Ms. Scott.
Laura Scott, I'm here. I'm alone at my work office.
And Mr. Witters.
I appear I'm alone in my work office.
And Ms. Spector Morgan.
I appear I am alone in my home office.
And I'm Chris Carley, and I'm also alone in my home office. We will be following our usual procedure this evening with a couple of minor diversions from that. We will call the cases from the agenda in the order in which they appear, and I'll explain about the diversion in a moment, which has to do with the order. And we will ask the appellant to be sworn in, which I will take care of, and offer us any testimony that they would like us to hear. We request that they confine their testimony, if at all possible, to a 10-minute interval. We will then ask the appellant to mute, and we will solicit testimony from anyone who is in favor of the appeal, followed by anyone who is in opposition to the appeal. Following that, we will check in with code enforcement to see if there are any comments from the administrative officials on the subject of the case. And then if there has been any information offered that seems to bear factual clarification, the appellant will have the opportunity to offer that factual clarification, not new evidence, prior to our closing the public testimony portion of the hearing. Under most circumstances, the board will consider and rule on each case before moving on to the next one. This evening, we have two cases on the public agenda that have been, that will not be heard this evening. The first has been withdrawn. That's case 4720, Barbara Mariano. That case will not be heard this evening. So if you're tuned in for that, you needn't stay tuned in. And I'm going to invite the board to a motion to open and recess case 5020 Bubbles Enterprises LLC to the November meeting.
Move to open and recess.
Mr. Wallner has made a motion. Is there a second?
Second.
All in favor?
Now we have to do a roll call.
Ah, right. Now they tell me. Mr. Wallner.
Aye.
Mr. Monahan.
Aye.
Ms. Scott.
Aye.
Mr. Winters.
Aye.
Ms. Spector Morgan.
Aye.
Okay. That takes care of case 5020 for this evening. So if you have an interest in that case, it will not be heard this evening. You need not stay at the Zoom site with us. Craig, I've got an administrative question for you. You there?
Yes, I am.
All of the other cases are recessed cases. Can we entertain a motion to open them all simultaneously so that, and then we can take them up in the order that we intend to take them up without having to go through this rigmarole with each case?
I think as long as you identify which cases you're opening, I believe that would be okay.
All right. I would like to solicit a motion from the floor to open cases 4120, 4320, 4520, 4620.
You also have to do 3720 also,
30.
because that was
I'm sorry,
recessed.
3720 as well. Yes, excuse me. Is there such motion?
So moved on the 5 cases.
Is there a second? Mr. Wallner made a motion. All right. Mr. Monahan made a second. Mr. Wallner, all in favor?
Aye.
Mr. Monahan?
Aye.
Ms. Scott?
I just have, I guess, is it me or Andrew voting? Because I'm sitting for Andrew. So we both can't vote.
You can vote because I have the conflict on 2 of them.
All right. I vote in favor.
Okay. And Ms. Spector Morgan? Okay. We will consider all of the cases reopened from their adjournment from last month. We are going to make a couple of changes, one change in the order in which the cases will be heard this evening, and that is that case 3720 will be heard first. That is Rosemary Hinton. And then we are going to hear case 4620 second before moving on to the rest of the cases. And the reason for that is that we have an alternate board member sitting in this evening for those 2 cases. And so we'll hear them first to allow that board member to go back to her knitting and or whatever else she's working on while we go on with the rest of the agenda. The first case then this evening is case 3720, Rosemary Hinton. The applicant wishes to expand an existing single-family dwelling and requests a variance to Article 2841H, Table of Dimensional Regulations, to allow a first and second floor expansion with the closest point 6 feet plus or minus from the westerly side property line, where a 15-foot side setback is required for property located at 21 Ironworks Road in an RS single-family residential district. I believe Mr. and Ms. Hinton, correct? We're going to unmute you.
Hi, I'm Rosemary Hinton.
Do you swear to tell the truth and the whole truth?
I do.
And Mr. Hinton, are you going to be testifying?
Actually, that's not Mr. Hinton, but Amanda,
Oh.
my daughter, will be.
Hi there, Amanda Hinton.
Very good. Would you identify yourselves for the record as you testify, and feel free to carry on and fill us in on why you feel the variance is appropriate.
Hi there, I'm Amanda Hinton. I actually reside at the 21 Ironworks Road residence. I've been there for, as of this month, will be 8 years. And we're asking tonight for approval for the variance for our side setback on the westerly side of the property, where the 15-foot side setback is required. We're allowing you we're asking you to allow us to expand within the 6 feet. The neighbor to the westerly side of the property, where the expansion would happen, has resided on his property for over 45 years. And he has no issue with the expansion, as it would not encroach on his property, nor would it inhibit any type of fire, police, or emergency personnel from accessing either property in the event of an emergency. The renovations we are requesting on the property would allow us to bring the older parts of the home, some of which are over 90 plus years old, up to the standard building codes, which would make the home safer, more accessible, and more functional. The renovations would have no impact on the surrounding areas, as it would allow us to bring the home up to the standards of the current homes in the neighborhoods.
Wow, has this been going on?
Can you fill us in a little bit on the details of what you'd like to do?
Yes, so what we would be doing is we would be expanding up where you see the two front dormers. We would be eliminating those two, which currently are leaking and actually are becoming a hazard that do need to be addressed. The back half of the house has a weird curved setback, so we would be squaring off that whole section of the house and then bringing it up one floor. So we'd basically be bringing, if you're looking from that front picture here, we'd be making that whole one level. So we'd eliminate dormers and make it 2 full functioning bedrooms. And if we can get, where are we at here? So right here, yeah, right there, that tiny little corner to the left there where the cursor's at, we'd be filling that in. And the property lines that are shown here from the video are not accurate. We did submit some prior zoning, so it is within give or take 6 feet. But what they have showing here is actually, like, it shows here that part of our bathroom currently is in the neighbor's yard, and that's not factual. So we'd be squaring that whole section of the house off from that side all the way to the front portion that comes out. So where that cursor is, bring that all the way to the right, and that would just be a big square. And that would allow us to add a second floor bedroom, bathroom. It would make the house more functional, as currently that front part of the house was built in 1919. So it's in need of definite renovations, just to get it up to safety codes for us currently.
Questions from the board?
Yeah, I do. I'm looking at the layout on the screen, and I'm trying to see how it compares to what I have submitted in the paperwork, and doesn't seem like the footprints are at all similar.
No, so the current one on the screen is not the accurate representation. I actually submitted some, my neighbor to the westerly side here, to the left of your screen. He had an assessment done on the property back in 1997, but it doesn't show the back expansion. So I did submit some of that paperwork, and it does show, and we did find where the pins were. So from using that paperwork from 1997, we did find the pins between the property line going all the way back to the back of the property. So the pictures that were previously shown do not reflect where the current property lines are.
Nick, were you talking about the building layout?
What was that?
I was asking Mr. Wallner. Nick, were you talking about the building layout?
Yeah, I mean, I'm looking at, it's labeled item 2 on our paperwork.
Right.
and it doesn't look at all what I see on the aerial.
So these are the current proposed expansions done here. So if you'll look here, you'll see that line to your right. You'll see where the 81 is. That is the current property line. And then you'll see where the dotted lines are. 81's pointing to it. The dotted line is where our proposed is, where we wanted to expand out. And then you'll see the solid lines coming up. One of them's kind of hard to see. It's by that. You'll see the dotted line right between that is it's kind of kitty cornered like this. So you'll see where that's drawn as the current. So we're just expanding out that tiny little section there on the property line side. And we're asking for the variance for that side. The other expansions that are happening in the front and on the left-hand side would be all within our property lines. It's just this tiny corner here that we're looking for the expansion. It's 84 inches.
So your entire house is actually in the setback, is that correct? Not the whole
Yes.
house, but
Yes,
the whole length of it. The setback runs right through the house.
yes,
Okay, which is 15 feet.
yes. So that whole, the current structure is, yes. Like I said, that part of the house was built back in, the front part was 1919, and then they did an expansion to the middle section of the house in 1950, I want to say 4 or 8. And then the back half, which is way over, was done, I think, 2005, from what I've gotten from records. It's very hard to track some of this stuff down, but I know that when we purchased the house as is, we were within that 15 feet.
Okay. Questions, other questions from the board? Anyone?
I just had, I guess, the clarification, and this goes back to what Nick said. The survey, the copy of the older survey
Yep.
shows the house before the recent expansion, which is why the aerial photos show a different house footprint than what the paperwork is.
No, the aerial photos are actually current. The house footprint, so the footprint you were looking at reflects the current footprint of the house, but the renovations that were done in the back half of the house were done in 2005, whereas the actual, what is it, where we found the line markers, what's that called?
The survey,
Yeah,
the
survey was done back in 97, so that was before the third edition was done to the house.
Okay.
Maybe Craig can put that up again for us.
Yeah. So if you'll see the front, okay, so we're looking at it, you'll see the pool in the back. That back long half here was done in 2005. And then that little square section there with part of it leading in was done around 1958. And then the full front half of the house was built in 1919.
Okay, I see it now. It was a survey map that threw me off.
Yeah, the survey map does not reflect that back half. He had that done, like I said, back in 1997, and he was kind enough to let us use that. It helped us find the survey markers, the pins that distinguish our division between properties.
And so you're just looking really to square off that back.
Yeah, exactly. Yeah.
Okay.
Yeah.
Thank you.
And it wouldn't encroach. He has no issue. He's been there since 1945, and he knows the property very well, and he doesn't have a problem with it. And he's been there for quite some time. So yeah, but that's because it's in our property. So we're just trying to square off that whole section, and then we want to go up from there and kind of make those 2 bedrooms that currently have dormers, make them more functional and safer, functional, to get rid of those dormers as well. Either way, they're currently leaking. We had 2 big trees taken down from the front because they were leaning over the house and causing rodent and rot. So unfortunately, we had to have those removed before we could start anything, but I think that will help with any future.
Ma'am, could I get your name again, please?
My name's Amanda Hinton.
Amanda, thank you. Any other questions from the board? Is there anything else you'd like us to know?
I think that's it. I thank you very much for your time and patience with me tonight.
Thank you very much. Is there anyone who would like to be heard in favor of this appeal? Is there anyone who would like to be heard in opposition to it? Let's see, did I get some correspondence on this one? I think I.
Yes, there should be two letters there.
Hello, can you hear me?
Oh, does someone want to speak?
Yeah, this is Deborah Samaha, and I have Ron Leahy here, who is the abutter.
Do you swear to tell the truth and nothing but the truth?
Yes.
What would you like us to know?
We submitted, this is Deborah. I'll let Ron go first. He's the main abutter to the property. So Ron is right here. I know you, I don't see him up on the screen, but he's right here, so go ahead, Ron.
I'm Ron Leahy. I'm one of the abutters to Amanda's residence. And I really do not contest, the expansion of the first and second floor. As long as this property remains a single family and not become a rental apartment or a rooming house or any more, because of the close proximity to my property, I just want it to stay the way it is. But as far as the addition goes, I don't have any objection to that.
What's your address?
Pardon me?
What is your address?
Yes.
25 Ironworks Road.
Good, thank you.
Ms. Samaha, did you want to offer some testimony?
I submitted a letter and I basically, can you hold on for a second? Peter, I don't know if you can hear my husband going in the back, but I wanted to submit a letter that our concern, again, we do not contest the expansion per se, but hold on for a second, please. I'm sorry. I just have to mute first.
Right.
Imagine what's being said.
I just did not. Craig, you there?
Yes, I am.
I don't have the letters because they probably were submitted last month.
Oh, did you get the email I sent you today?
Yeah, but it didn't have anything.
Yeah, I don't see it for 3720. I see all 6 other letters, and I have the original file from last month.
So
And
I
we
don't
only
think
have
20 was in today's except for the sketch. So would you do me a favor? Do you have them or?
Oh, yeah. Yep.
Either Nick or you just read them into the record when it's time.
I can read it right now since Miss.
Yes.
I'm sorry. Go ahead.
She's back.
Go ahead.
Ms. Samaha, we're going to read a couple of letters into the record and then I'll come back to you.
Sure.
Okay, so the only letter I have is dated August 2 to the members of the zoning board. Being one of the main abutters to the residents at 21 Ironworks Road, I do not contest construction of enlargement to the second floor of the home as long as this property remains as a single family home only. Ronald Leahy, 25 Ironworks Road. And that's the only letter I have.
Okay. And I have the other one here then from Mrs. Samaha, dated October 5th, 2020. Dear Mr. Walker, in response to your letter regarding case 37-20, I'd like to submit the following input. They've lived in the neighborhood for 25 years. They've observed, with our current owner, they've observed a number of people coming and going from the residence. Additionally, we have seen several vehicles parked in the property in the front and side yard, not utilizing the driveway. These include campers, RVs, pickup trucks. In our neighborhood, it is unusual to park a camper or RV in your front lawn for an extended period of time. The owner mentions the aesthetics of the neighborhood as being a concern to her. It is also a concern of ours. Our question is this to create more room for family members, or is this potentially going to be a rental property or rooming house? If so, we are opposed expanding this house to become a multifamily rooming house or subletting to non-family members. Thank you for your consideration in this matter.
Thank you, Craig. Ms. Samaha, you're back up.
So that was my letter, and I think it says what my concerns are. Just that we've seen a lot of action there, and a lot of vehicles parked for extended periods of time, and you know, it just, again, we don't object if it's strictly related to family, but if it is not. And I don't know how there would be any accountability for that if you do approve this. I do believe this, I'm not sure, is this zoned for residential only? I don't know how all that works, but I just have a concern from the neighborhood about the additional vehicles that are parked all over the property. And I'm just thinking, if it's a bigger house, we just want to be clear that this is a single family dwelling.
Okay. As far as the conditions, whatever the situation is that's presented to the board is assumed to be the case for the purposes of any decision we make. So if, for example, we were to grant the variance and that it was stipulated that it was a single family house, family members only, and that the addition was not for any additional non-family use, for example, then that's the case. Never mind what the zoning allows. So whatever they present to us this evening, that will be what the board will take on faith as being the situation going into the future.
Okay, thank you.
You're welcome. Is there anyone else who'd like to be heard?
Could I rebuttal real quick, or?
You will have your chance, but I have one more step to take.
Okay.
Mr. Walker, any comments?
Yeah, first one was to verify, and we've mentioned before, the lot lines that show up on the GIS are by no means surveyed lot lines, and they're just for estimation purposes only. As far as becoming a multifamily home, it is in a district where an accessory dwelling unit would be permitted. But and they appear to have enough frontage and land area to meet the minimum requirements to be allowed to do that, as would many other residences in that neighborhood. It would require a special exception if that was ever to change in the future. But the current request here is strictly for a single family dwelling.
Thank you. Ms. Hinton.
Hi there. Yes, our request is strictly for a single family home. Currently, there are 4 of us residing there, all family. I have no intentions to sublet, rent the property out. My son is currently enrolled in the school district, and I plan on residing there for as long as humanly possible. Currently, I work for the state of New Hampshire. I've been there for about 16 years. I've actually grown up in the area, and I intend on staying here. And I would like the variance granted so that I could make my home more comfortable for myself and my family. In regards to traffic coming and going in my home, I grew up around here, so I do have a lot of friends in the area. We do have barbecues and things like that. We vacation, me and my son vacation in the summer. We do have a RV or a pop-up camper parked there right now. We could pave the land right now and make it a driveway if that's would make the neighbors more comfortable. But yeah, I have no intentions of renting out the property. I've been here 8 years and plan on staying for many more.
Thank you very much.
Thank you.
With that, we'll declare the public testimony portion of the hearing closed. We have a request to grant a side yard setback variance. We heard testimony that the variance is required for a section of a small section of a larger addition, and that the conditions are such that anything done on that side of the house is already within the setback, which is peculiar to that lot. Ms. Spector-Morgan, what are your thoughts?
I have no issue with this. The lot is certainly uniquely shaped, and the house is situated all the way over towards the property line. The expansion they're seeking is completely reasonable. It's just squaring off the house. I don't think there's going to be a diminution in property values. And I think, given the fact that the house is already within the setback, that this would be consistent with the spirit of the ordinance and the purpose and intent. So I would be in favor of granting this variance.
Thank you. Ms. Scott?
The other Laura said it much better and more eloquently than I had planned to. I agree.
Very good. Mr. Monahan?
I concur with the two Lauras.
Mr. Wallner?
And I too concur, and just, it's only 2 additional feet into the setback with this, so I don't see this as a real hindrance to that. So I think substantial justice would be done if we were to grant this.
I agree with all my colleagues and their reasoning. Would anyone care to make a motion?
I move that we approve the variance.
Is there a second?
I'll second.
It's been moved by Ms. Spector-Morgan and seconded by Mr. Monahan to grant the variance. Is there any discussion on the motion? All right, in that case, we'll take the roll, starting with Mr. Wallner.
Aye.
Mr. Monahan.
Aye.
Ms. Scott.
Aye.
And Ms. Spector-Morgan.
Aye.
And I also vote aye. The variance is granted. And that concludes our discussion of case 3720. We will now move on to case 46-20, which is Howard Rover, if I'm pronouncing that name correctly. The applicant wishes to construct an elevated 4-foot by 12-foot deck sitting area and requests a variance to Article 28.4.1H, the Table of Dimensional Regulations, to allow a 9.5-foot setback from the rear property line where a 20-foot setback is required for property located at 60 Rumford Street in an RD residential downtown district. Is Mr. Rover or someone representing him here?
I am on the phone.
Okay, did I pronounce your name correctly?
You did, sir. Thank you.
Do you swear to tell the truth and nothing but?
Surely do.
All right, what would you like us to know?
First thing, Andrew Winters knows too many people that he's got to keep getting off all these cases, I guess I would say, for one thing.
We'll have a word with him after the meeting.
That's fine. I don't have a ton to add. Let me see. I'll just go down these handy little notes here. I think I laid everything out pretty carefully in the application. Right downtown. I'm in this weird area where everybody's house is in violation of the present code. The interesting part about it, I thought about this morning, when I am in my bathroom and I look out the window, I am literally looking onto the person's property. The whole back of the house is already in the setback. I think the back of the house sits 4 feet from the setback. Compared to what I'm looking to do, as I said, I think I laid it out in the application, I'm putting this minimal deck on there for the purposes of just using the property to the fullest extent. It's going to look a heck of a lot better than it looks now. Right now, it looks like someone started to do this and realized they couldn't do it and stopped. I have these double doors to nowhere. So I would just like to make them either double doors or single doors to somewhere and make some reasonable use from it. I did contact the abutter to the back of me, who would be the property that would be that would be most have anything to say about it. They wrote a letter and I attached it to my application saying they had no objection to it. For the most part, I imagine it's going to make the property look as much as I've done with it in the last 5 years. It'll look even nicer still. It'll certainly be a benefit to the neighborhood and not a detriment to it. I don't know that I can add much more than that. I think I laid it all out, but I'm certainly open to answer any questions.
Is there a steep drop from the street to the backyard at your house?
Yeah, it goes. So basically, the front of the house is level, and then you get about. I think it's where they added on to the house. I think I don't know the exact history behind it, but I think it's where they added on to the house. It drops. So my backyard drops down. I'm guessing 6 feet or so. So there's a retainer wall, and then there's the backyard back there, and that's what the back of my house the doors open on to that drop, and that's where I was looking to put the deck onto.
So the deck would be more or less level, maybe a few inches lower than the first floor of your house.
Yeah, just maybe a few inches, a few inches lower, I would imagine,
Yeah, okay. Questions from the other board members?
Could I just see an aerial on that property, please? Okay, thank you.
Anyone else have a question? Mr. Rover, is there anything else you'd like us to know?
No, I appreciate finally getting on here. I know we tried this last month, but no, I think I tried to lay it out as detailed as I could in the application. So thank you.
Okay, thank you. Is there anyone who'd like to be heard in favor of this appeal? Is there anyone who'd like to be heard in opposition to it? We do have a couple of letters. One dated July 27th, 2020. It is my understanding that Howard Rover at 60 Rumford Street is seeking a variance to build a small deck sitting area on the south side of his home, and then he needs a variance to do so. As the property owner or butter that is affected by this proposal, by this proposed construction, and thus the need for a variance, I have no objection to Mr. Rover's proposal, and this is Elaine Merchant who lives at 12 Hanover Street. We also have an email from Carrie Mobile, who is a resident of 43 Rumford Street, directly across the street from Howard Rover at 60. We fully support the project to add a 4 by 12 foot deck to his home, which will result in a variance from Article 2441H. That is it. Craig, did I get all the correspondence on that?
I think there's one more that was in the application package from Heidel and Michael Frasica.
Yes, sorry. Thank you. To whom it may concern, this one's also July 27th. Our next door neighbor, Howard Rover, is petitioning with the ZBA to build a small deck sitting area off the southern side of his home. Howard obviously takes pride in how he maintains his property, and we feel that the proposed addition would be both appealing to the eye and beneficial to the quality of the neighborhood. And this is signed by Heidi and Michael Frasica, who live at 58 Rumford Street. Any comments from code enforcement?
Nope, I don't have anything additional to add for this one.
All right, in that case, I think we can close the public testimony portion of the hearing and invite the members of the board to discuss the case. We have a request for a variance to allow a deck in the backyard of an existing house on a small lot on Rumford Street. It seemed to me from reading the plans that there would be no way to add a deck back there without violating the setback, since the lots are all so small and the houses go right up to the property lines. Mr. Wallner, what do you think?
Exactly. The back of the house is almost on the property line. This is only 9.5 feet away from the property line, so it's certainly, to me, is a minimal incursion into the setback.
Mr. Monahan.
Yeah, I think this is a dense neighborhood, and so this seems to be an appropriate use, and the additional 4 feet, I think, is fine. So I'm supportive.
Scott. Oh, sorry, did I interrupt you?
I'm good.
Okay, Ms. Scott.
No, I think it's an appropriate use, and I agree with the homeowner. It probably looks like they were probably going to do something, realized they couldn't, and stopped. But I think it will probably enhance the neighborhood and the building, and everything in that neighborhood is pretty much in the setback. So I think it's a reasonable request.
Ms. Spector-Morgan.
I agree with my colleague.
As do I. Would anyone care to make a motion?
I'll make a motion to grant.
Ms. Scott has made a motion to grant. Would anyone second?
I'll second.
Ms. Spector Morgan has seconded. This is a motion to grant the variance for the reasons discussed. Any discussion on the motion? All right, we'll take the roll, starting with Mr. Wallner
Aye.
and Mr. Monahan.
Aye.
Ms. Scott,
Aye.
Ms. Spector Morgan,
Aye.
and I also vote aye. The variance is granted, and that concludes our discussion of case 4620 this evening.
Thank you very much.
You're welcome. Now we come to the next case in our agenda. I believe we thank Ms. Scott for her help this evening.
Thank you for having me, guys. Have a great
Thank you so
month.
much.
Bye, Laura.
Thank you so much for looking in on us.
Not a problem.
We'll see you at the next one.
Yep, I hope so.
And Mr. Winters rejoins us.
Yes, I do.
All right, glad to see you're still at your station.
What station?
The next case this evening is 4120 Fred L. Potter for 135 NSS LLC. The applicant wishes to install two freestanding signs. Sign number 1 is a 4.58 square foot in area and 7.9 feet tall. And sign number 2 is 24.08 square feet in area and 7.4 feet tall on a lot with a sign number 2 located in the corner no obstruction area, and requests the following. A variance to Article 2868 signs permitted in residential districts to allow two freestanding signs on a lot in a residential district where only one freestanding sign is allowed. A variance to the provisions for signs permitted in residential districts to allow two freestanding signs on a lot in a residential district with a combined area of 28.66 plus or minus square feet, where one sign is allowed and the maximum sign area allowed is 20 square feet for a single sign. And to a variance further from signs permitted in residential districts to allow a height of 7.9 feet where sign 1, where a maximum height of 6 feet is allowed in a residential district. Variance to that same provision, signs permitted in residential districts to allow a height of 7.4 feet for sign 2, where a maximum height of 6 feet is allowed in a residential district. And finally, a variance to 2867 signs prohibited under this ordinance to allow a 7.4 foot sign to be placed within the 30-foot triangular area adjacent to the corner, where no obstruction is allowed between a height of 2.5 feet and 8 feet above grade. All of these, if granted, would be for the property located at 135 North State Street in an RN residential neighborhood district. Mr. Potter.
Thank you. I appreciate the hard work of this board over the years in what is a very complex redevelopment of the former St. Peter's Church property.
May I swear you in?
Pardon me?
May I swear you in?
Oh, I'm sorry. I apologize.
You promise to tell the truth?
I do.
Would you identify yourself for the record, please?
Fred Potter and Mr. Josh Messenger is with me too, and he'll start with the details in just a minute after a brief introduction.
Take it away.
So I apologize that I started to speak before being sworn in, but this board has spent a great deal of time on this project, the former St. Peter's Church project, which, as you know, is bringing in a combination of residences and the renovation of the Rollins Mansion, which was in disrepair, to the former St. Peter's Church site. The property that Craig is highlighting for you there on the corner is a property in question. And this is the future home of an affiliated organization of Kidsbacks, which we run on the opposite corner of Franklin and North State Street. And this would be where the Legacy-Wise operation, which is services for low and middle income families in their estate documents. And it's a live-work use. So it's a combination of office and residential uses for interns as allowed by the board in its prior work. Net from when all this began, the signage is actually reduced, but the basic mission here is to do two things. One is to mirror the multi-tenant side that's on the 125 North State Street property. and two, to provide a demarcation between the Pocket neighborhood and this building. So Josh can present the signs, and then I can share a little bit more about the neighborhood if helpful to the board.
Josh, may I swear you in?
Yes.
You swear to tell the truth and nothing but?
Yes, I do.
Would you identify yourself for the record, please?
My name is Josh Messenger. I'm representing Fred Potter, and I work for Advantage Signs.
What would you like us to know?
We are proposing to locate the sign 13 feet back from the property line in the corner of the building. And if you look at your attachment with the 4 photos and drawings, I think what's important here is that there's a picture taken from a vehicle, and the vehicle is at the stop sign, and this sign would be behind the vehicle, so there is no obstruction that is visible. As you can see, the bush is more of an obstruction, and that will be moved. And as Fred said earlier, what we're trying to do is bookend the property to 125 and really make a nice statement of a sign. And really, it's just a mirror of the other property as well.
Looking at the photograph, where would the sign be relative to where the bush is now?
It would be behind the bush, so it's going to be 13 feet back from the corner of the stone wall.
So to the west?
Yes.
Of Church Street?
Correct.
Okay. All right, carry on, please.
As you can see from the other documents, it's a nice architectural look that's designed to the to some of the highlights of the building is what we tried to design it as. And we don't see that this would, we think that this would add value to the neighborhood, and it would certainly allow for the tenants to be identified, as that could be a concern for emergency vehicles or for just clients trying to do business. So
the sign that is on the corner is the multi-tenant sign, nearly identical to the sign that is on the opposite corner at 125 North State Street. It's being in that location at the base of a grade that goes up to the building, gives greater visibility to the architectural restoration work that's been done on the mansion, former Governor Rollins' mansion. And were we to move it back further, that would further interfere with the visibility of the extensive renovation work. The other piece that is coming from the Pocket neighborhood side, the old church auditorium, which you can see now in the background of all of this. It's more like a lamppost. It's very similar to, if you have the materials we sent in August, very similar to lamppost signs around the neighborhood. And indeed, the size of the sign is similar to other professional office building signs in the neighborhood. In this particular case, legacy-wise is a startup. It will be moving gradually, and because it is serving low and middle-income families, will have very modest revenues. So we anticipate there will be multi-tenants sharing the building until the time that legacy-wise fully occupies all of the space. Therefore, the need for the multi-tenant sign for clarity, but we've moved that away from the Pocket neighborhood. And the identifier down by the Pocket neighborhood, the lamppost and Governor Center logo, really distinguishes this building from the new Pocket neighborhood. There has been considerable delivery confusion since the Pocket neighborhood went in. It'll work itself down over time, but this is designed to help as one is on that driveway to distinguish between the pocket neighborhood, which you now see the cottages that are there and the, thank you, Craig, and the large mansion. That is a shared exit driveway, and the sign in that area will help distinguish for someone who happens to be on that driveway. And it's very modest, as you see, an identifier, whereas the corner side is more of a traditional business sign, much like we did on the other corner at 125 North State Street. Be glad to answer any questions, but that's a design philosophy. This is carefully integrated as part of a historic renovation and designed to complement, not detract from this work.
And can you explain to me about the confusion? What sort of confusion has occurred?
Well, normally there wasn't previously any 131 North State Street address. That is the address for the 8 cottages that are now there where the old auditorium used to be. I believe there may be a sign coming for that pocket neighborhood. I don't know, some kind of demarcation. But delivery vehicles which go around the mansion, the 135 would be the mansion side of that driveway. The 131 will be the other side. And someone actually entering that pocket neighborhood where delivery typically would enter behind the mansion over the shared driveway. That's where there's a walkway, which affords access to all 8 of the cottages. And that's what we're talking about, Mr. Carlin.
That the people making deliveries don't know where to go?
Correct.
Okay.
They're in that shared driveway, but the addresses aren't clear. This signage will clear that up.
Other questions from the board? Mr. Potter, did you have more you wanted to add?
No, thank you. I'm happy to answer any questions or share more about the design philosophy, but I think you can probably see that aesthetically just from the numerous prints that have been provided.
Could you, one of the things that has caused the need for all these variances is this particular use in the residential district. Could you speak to how that might influence the board's findings of whether or not a variance is appropriate?
Well, certainly I'd be glad to do that. This property truly is unique. As you know, it is a upgrade which allows preservation of the building for uses that had been similar. There had been, during the period of the stewardship by the Bishop of Manchester, there had been residences, priests in the building, and community uses on the first floor for meeting space. The residential spaces have been materially upgraded on a live-work use variance granted by this board earlier, which let us save the building. You may recall John Shorelian looked at this building and the carriage house for subdivision to expand the cottages in the pocket neighborhood. It just economically didn't work. There was more than the value of the building involved in demolition before the renovations could just start. So this identifier will help people know that if you live here, you live in the Governor's Center as opposed to live in the pocket neighborhood. And those will primarily be postgraduate students serving a year or 2 in community service for low and middle income families. So this identifier will help for people looking for those people as well who are short-term residents. So having some good signage about being in the Governor's Center as opposed to being in Rollins Court would be a benefit for the residential use. And then of course, for the commercial use, the multi-tenant sign is a fairly standard approach all up and down the street for buildings that have been converted to commercial uses.
Thank you. Any questions for Mr. Potter from the board? Craig, I have a question for you.
Yes.
Has either engineering or traffic weighed in on this?
Not officially in writing.
Okay.
But I can tell you that General Services did not support it.
Did not support it.
Correct. They're concerned with the obstruction at the intersections.
Okay.
I have a question for Craig as well.
Okay.
Craig, so they've provided a plan showing some other signs in the neighborhood that would be consistent with this one. I'm wondering how many of those, if any, are non-conforming and how many of those have been allowed by variance?
Oh.
Okay, never mind.
Yeah, no, no, off the top of my head, I cannot say. You know, one of the signs is located here. Most of those believe that, you know, office uses were created by variance in that building, if I remember correctly. The other one there is down at this intersection here, right at that building. That's been there forever. Again, those were related to some zoning relief on that building. You got Binney Media right down here at the intersection. That's in an institutional zone, so those were conforming uses in that location.
Yeah.
And then there's another one, you know, on this portion, I think, facing towards Church Street and under the same circumstances. And oh yes, and the other one right here, yes, that is a legal attorney office, I believe, professional office, and that use was also established by variance too. Okay. So maybe I do know the history behind them.
Sorry, I didn't mean to spring it on you.
Any other questions? Is there anyone who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? I do have a couple of letters, or their emails. This one is from Melissa Bernardin. Has a decision been made on the Fred Potter case? We are residential abutters at 17 Church Street. I have a conflict. 10. We're concerned about the obstruction of view for drivers heading eastbound on Church, approaching the State Street intersection, and for drivers heading northbound on State Street, turning left onto Church Street. We also have an email from Jack Hutton, who lives at 137 North State Street, who says that he can think of no reason why a sign that large would be needed at 135. What is the sign going to be for? Is this a new business in a residential neighborhood? Mr. Potter, would you care to offer any factual clarification in response to anything you've heard?
Mr. Collier?
Thank you.
There is one other person who wants to speak.
Oh, I'm sorry.
Pardon?
So there is one other person who'd like to speak, and Meredith Hatfield.
Oh, I'm sorry, Ms. Hatfield. I have bungled it again.
Thank you very much. Can you hear me okay?
I can. Do you swear to tell the truth?
I do. My name is Meredith Hatfield. I live at 5 Perkins Street in the neighborhood, and I need to disclose that I represent Ward 4 on the City Council, and I am here in my individual capacity as an interested citizen and not on behalf of or at the request of the council. I thank Mr. Potter for all of the work he's done on this site. It looks beautiful, and it's wonderful to have people living there. I do have concerns about the size of this sign and some of the issues that have been raised with visibility, both for cars and as well as for bicyclists and those of us who walk it often. I wonder if a smaller sign wouldn't meet their needs. And I want to point out that the sign he referenced at 125, which is his other property, on the corner of Franklin Street is in quite a different situation because it's at a roundabout and it's just feels set back further from the road, so it doesn't feel like a barrier when you're either on foot, bike, or in a car. So it seems like given the safety issues and also the fact that it is a residential neighborhood, that it would be nice to have a slightly smaller sign that was more in keeping with the area, and that, as they're being sensitive on the other side of the property with that very nice governor's sign, just to respect the people living in the pocket neighborhood, it would be nice to have something a little bit smaller on the Church Street side. I'm not sure they've really shown that there's a hardship in this case if they were required to do something a little bit smaller. So I certainly, respect and understand their need for a sign, but it does seem like the needs could be met with something that was just a little bit smaller. Thank you.
You're welcome. Is there anyone else who'd like to be heard, either in opposition or in support of the appeal? Any comments from code enforcement?
Just a reminder, the uses that exist here were established by variance. There was a variance granted to reduce parking, required parking from 50 to 14 spaces. And that was, based on the representation that there would be very low impact and very small need for parking at this location. On top of that, I would say, if this is granted, that just a reminder, the sign does require an architectural design review and would have to go to the planning for that.
Thank you.
Can I ask,
I'm sorry.
Oh, I'm sorry. Can I ask Craig a question, or should I wait until the delivery?
No, ask him now.
Craig, you and a couple other, I think at least one other person mentioned that there's the objection from the city relates to the obstructing or visibility at the intersection.
Yes.
If we were to approve the variance, is that must go through another round of review for safety, correct?
No, this is the safety aspect of it. It is already in the ordinance to prohibit anything between 2.5 and 8 feet in height within 30 feet of an intersection. The only other once you have granted it, it is allowed, and it would be difficult for any other party to deny it after you have approved it.
Thank you.
Mr. Potter, I think I'm finally going to get back to you here. Do you have anything that you'd like to offer in response to what you've heard?
In response to Laura's observation, those, as pictured, all of those signs are in this blended area, some of which are in residential zoning areas. And this is actually similar in size to those. With respect to the economic hardship, the preservation of this building has been a monumental task, substantially above anybody's cost estimates. And it will be necessary to use the commercial spaces until Legacy West can absorb them in its operations more charitably focused. There is one possibility that comes to mind based upon the selectwoman's or councilwoman's comments that, unlike the other building, if we were to drop that professional offices sign because there would be no unnamed tenant there, we could drop one of the panels and reduce the size downward for that. We very much hesitate moving it up the hill because after spending literally $4 million to preserve this historic property, to face the prospect of blocking it further by moving up the grade would be disappointing. But we understand. I've driven there many times. There's minimal impact, and as Josh notes, the net result will be fewer obstructions once the signs and the bushes moved and so on. But if a condition to reduce it by the height of one of those slats is helpful to the board, we could live with that, given that we don't anticipate more than 4 entity occupants in the spaces that are there.
Any other questions from the board?
Oh, what's the height of what's the height of the professional offices sign?
Josh would know. Each one of those are the same. You see those 5 slats there. We propose to eliminate one of them and just lower the sign by.
Right. Yeah. But by how much? I can't. The print is so fine. I can't see. It's too small for me to read.
Josh, do you have the dimension on each of those panels?
I do have the dimension. It looks to be like 8.5 inches is the slat dimension.
So you'd have 8.5 inches in the gap that would go away. So it sounds like maybe 10 inches that it would be lower. And thank you for your time. this has been a long process, and we're finally in the final stages. We'd appreciate moving it along if possible. Thank you.
Thank you for all your work on the project. I guess with that, we'll declare the public testimony portion of the hearing closed. We have heard a request for signs that would violate the zoning ordinance in a residential neighborhood. We've also heard testimony that they go with a building which is not a residential use, for which we have granted variances in the past. We also heard testimony that there's a concern about safety with one of the variances in terms of traffic obstruction. Mr. Winters, what do you think?
I should note that I hadn't noticed this when I first looked at the package, but what the one of the signs they were referencing is the sign in my office. I can actually see it right now. I don't think that creates any kind of conflict. It looks like it's just for comparison purposes. I'm farther away than any other of these other buildings. But as far as the substance of it, I'm undecided, to be honest. I want to hear what other people think. I mean, the property is definitely unique. Even a lot of the properties in this area and in this zone are, but it's particularly unique in terms of the shape of it and the location. It's right on the edge of this district. There's a bunch. I'm looking at the zoning map. There's a whole bunch of districts really, clumped together. So it's in a residential district, but it is at a fairly busy intersection with multiple professional type offices nearby. So I definitely see a unique element to the property, and frankly, I see some hardship. Because of the unique nature of both the lot and the building that's there, preserving the historic building, people living there that we've permitted. What I'm getting hung up on, to be honest, is the obstruction that was mentioned by the city apparently, and by I think at least one of the abutters. And I don't know exactly how to. I don't know how to decide that, because it's hard for me to say if that's a safety issue, if it's just an appearance issue. I know the area very well, but it's hard for me to say. If I thought it was a major safety issue, I'd have a big problem with that.
Ms. Spector-Morgan, you're muted.
I'm unmuted. I have dogs. I have many concerns with these requests. First, I don't understand why we need two signs. I've heard the explanations, but I'm not convinced that we need two signs. Second, if General Services isn't in favor of it being in this triangular area, I have a hard time agreeing to that as well. I mean, the bush is there, but the bush you can certainly see through more than you could see through the sign. It seems to me that the entire large tenant sign could be moved to the location of the other sign that they're proposing, and you could kill two birds with one stone. And then I don't think there would be really any objections to the size of the sign. So I'm not convinced the property is unique in terms of putting it in that corner. I agree with Ms. Hatfield that it's very different from the sign at 125, which is on the roundabout. And I would not be in favor of any of these variances at this point.
Mr. Monahan.
The applicant made a good case for why the signage is necessary, but I'm not sure that I heard why he couldn't find signage that would conform with the ordinance. I don't know that they need to be taller and bigger. It's fair enough that there should be signage there, but like Laura, I'm skeptical of what's before us.
Mr. Walner.
Well, I'm okay with some of this. I'm okay with allowing two freestanding signs, and I'm okay with the single, what they call the lamppost sign. In terms of the ones that list all the properties, I have a real problem with places that have multiple listings, because to me, if you're trying to find a place and you're looking at 4 signs, it really causes distracted driving, because you're trying to focus on what they say. And if you make it smaller, it makes that exercise a little harder. So I think I'd be in favor of the size being okay, but I think being farther away from where it's located maybe would be the solution to that.
I'm inclined to agree with Nick about the 2 signs and about the post sign, which strikes me as being pretty minimal impact. Although we didn't hear a strong case made for why signs are needed at all, or outside of the variances are needed. The fact that this is a commercial use in a residential neighborhood, which is something that the board did grant because of the peculiar nature of this building, tends to push me in the direction of seeing a hardship there because of this site and the use. What concerns me about the corner is the same thing that concerns everybody else, which is the safety issue. However, I'm not satisfied that I know that the city engineers and or traffic and or general services have actually looked at this particular proposal and at that site and declared themselves unhappy with it, or whether they've just made a general remark that that's the rule and we assume not violate it. Is there a reason why in this case it might not have the negative impact that it could have somewhere else where it wouldn't be allowed? So
Chris, I would strongly suggest, though, that if you would be swayed by testimony from Public Works, that you would recess this case then and allow Public Works to comment on that.
Well, that's what I was drifting toward.
Yeah.
But I don't know that the rest of the board seems to be fairly firm in their opinion, so it may not be necessary. What do people think about that idea?
I'd like to hear from Public Works.
Yeah, I think that's only fair. I mean, Craig said it's nothing's been put in writing. It's just kind of what he heard. So we don't know exactly why or how strongly they feel about it.
Well, yeah, and just to clarify, early on when this proposal came forward and I solicited some information, I received a couple emails from people up at General Services and in the engineering office, but they weren't formal to this, and I don't have them in front of me. So I would like to give them an opportunity to formally submit something of that nature.
It would make me more comfortable that I understood the situation. What do you think?
I guess we could vote on maybe 1 through 4 and recess number 5.
1 through 4 are all the post sign and the number of signs?
The number signs, the post signs, correct. And then just number 5, because that's really, I think, the key issue is the blockage review for I think most of us.
Also, I don't know that we're necessarily ready to prove the height of that sign either.
Fair enough. I could agree to that too.
So would that mean 1 through 3 as I read this?
1, 2, and 4, I think would be okay.
Well, 4.
It's sign number 1 that I think we have an issue with, isn't it? Let me just go back and look at my notes.
Yes.
Sign number 1 is the triangular sign. Sign number 2 is the lamppost sign, I believe.
I think it would be important for me and perhaps for the applicant to continue all of them. I don't see any benefit in voting on some of them now and some of them next time. And I think that Public Works' opinion of this freestanding sign could weigh in with how I feel about the other variances as well, particularly the height and whether or not there needs to be 2 signs. I think the applicant has heard a lot of comments from all of us tonight. They might want to reconsider the design. If we're going to continue 1, I think it just makes sense to continue them all, but that's just my opinion.
I think there's considerable wisdom in that. What do the rest of you think?
I agree.
Tim?
Yeah, I agree. I'd like to hear from General Services.
Nick, what do you think?
Well, it sounds like the majority is to recess all 5, and I would go with the majority.
All right.
I have a question though. So the applicant heard some feedback tonight. If we recess it, but they want to come back with some adjustments to what they proposed, They wouldn't be able to do that if we just recessed it, right? They'd have to file a new application.
It depends on what those adjustments are.
I think if they're asking for less forgiveness, they can do it. Craig, is that true?
As a general rule, yes, so that would be correct.
Okay.
Okay. So if they diminish their impact.
Don't want them to have to come back 3 times. So.
Right. If they come back with a bigger sign, I would think that'd be a new case. But some
yes,
tiny piece of intuition I have suggests that they won't do that. Okay, do I hear a motion to recess the case to the November meeting, pending soliciting testimony in November from the Public Works or whoever else in the city, among city staff, has input to give us on this?
So moved.
Is there a second?
Second.
Any discussion? All in favor? Oh, yeah, you can't do that. Mr. Wallner?
Aye.
Mr. Monahan?
Aye.
Ms. Spector-Morgan?
Aye.
Mr. Winters?
Aye.
And I also vote aye. That retires that issue for this evening. We will revisit that one next week. And do you have any questions, Mr. Potter, about what we've asked for?
Actually, the case will be taken up next month on November 4th.
Oh, yeah, next month, excuse me, misspoke. Mr. Potter, do you have any questions about what we're asking for?
Thank you. I do not, and will certainly confer with further with the city departments. Thank you. See you in a month.
Thank you.
Good night. Next case is case 4320, David Clayton for Miranda and Andrew Hardister. The applicant wishes to expand an existing residential structure and requests a variance to the table of dimensional regulations to allow a first and second floor expansion with the closest point 7 feet from the northerly side property line, where a 10-foot side setback is required, for a property located at 14 Dunkley Street in an RN residential neighborhood district. Mr. Clayton, are you with us?
I'm here. Can you hear me?
Yes, I can. Do you swear to tell the truth and nothing but?
I do.
Would you identify yourself for the record as you testify, please?
I'm David Clayton.
And would you fill us in on why you believe a variance is appropriate in this case?
I'm an architect, and my daughter and her husband own the house on 14 Dunkley Street, and I am hoping to move in with them. I'm 80 years of age, and I do really need to find a place to live close to the family. As an architect, I've reviewed the possibilities for giving myself as nice a space as I can. And the first idea would be obviously to build a self-contained addition in the rear yard, but this has proven to be a problem because it's a relatively small rear yard. My 2 grandchildren are soccer players, and that's their soccer field. And also an addition would crowd out the existing house because of the rear yard setback. I've settled on a solution to build a second story, and it seemed very logical and reasonable to build up over what was an existing garage. That's on the picture, it's on the right-hand side there. It provides all the space I need, and architecturally, I think I've been able to put a second story on to a single story building in a way that it blends in. The request for a setback variance is the existing garage is in fact within the setback. It's a 10-foot setback, and the existing garage is 3 feet into that setback. And logically, I just want to build up on that garage wall. So that's the variance I require. And you'll also see on the picture there that the side yard is in fact the rear yard of the property on Humphrey Street. So they have a larger setback in that area. So if I was to build up, I wouldn't be crowding out any future expansion of that property. I think that's it speaks for itself, the illustrations I've given you. And I'd just like any questions you might have.
The mudroom addition on the first floor, that is also in the setback?
No, I've set that right on the setback. So okay. I've achieved the 10 feet. So it's only the second story part. And the mudroom.
The existing footprint.
Yeah.
Other questions from the board?
So the setback, that's the only variance you're going to need to do this second floor, make a second floor?
Yes.
Other questions? Anyone? Is there anything else you would like us to know?
There is a letter, I think is on file, the immediate abutter that's mostly affected. He's been consulted and he has no problems with the addition.
I believe we have his letter and I'll read it into the record in a moment. Thank you very much. Is there anyone who'd like to be heard in favor of this appeal? Is there anyone who'd like to be heard in opposition to it? Any comments from code enforcement?
Nope, I don't have anything additional to add to this one.
Very good. We do have a letter. This is addressed to David Clayton, and it says, "This is Mark Emmons, Andrew and Miranda's neighbor at 1 Humphrey Street. Please present the following message to the zoning board. As an abutter to the northern side of the Hardisters property, I would like to offer my support to the planned addition to their house. I've seen the plans for the addition and see no negative impact on my property. The addition will help my neighbors to care for a family member and add value to the property as well." With that, we'll declare the public testimony portion of the hearing closed. We have a request to add a second story to a footprint which is already in the setback, which would therefore require a variance to the setback requirements because it's expanding non-conforming use. Mr. Wallner, what do you think?
I think the, part of the addition is over an existing structure where the garage was, so I think there's no change there. And the other one just adds another foot or two into the setback, I believe, maybe even less than that. So I think it's just minimal intrusion into an existing setback, and I see no issue with it. I think it's certainly going to not lower property values in the neighborhood. I think the spirit of the ordinance will be observed. Certainly substantial justice. I think the hardship is really no other place to do this reasonably well.
Mr. Monahan.
Yeah, I agree with Nick. I think it's, asking for 3 feet of relief in a neighborhood where houses are pretty close together to begin with. I can see with the type piece of property, I think it's a well-designed and won't have adverse impacts on the neighbors.
Ms. Spector-Morgan.
I agree. The only other place to expand the house would be in the backyard. And while this soccer field doesn't convince me there's a hardship, I am convinced that it would be an awkwardly shaped and unfortunately narrow addition. So where the house is already in the setback and it's just going up, and particularly given the layout of the houses that abut the property, I think it is a reasonable use of the property, and I would be in favor of granting a variance.
Mr. Winters, what do you think?
Yeah, I agree. I agree with all.
Very good. I agree with everything my colleagues have said. I think the sketches make it clear that the design is well resolved in that spot, and I can't see any reason why they shouldn't be able to add a second story to an existing footprint. It doesn't strike me as being creating any greater violation of the ordinance than it is now. I don't see what would be gained by anyone by saying no. Would anyone care to make a motion?
I'll move approval.
Is there a second?
I'll second.
Is there any discussion? All right, we'll start this time with Mr. Winters.
Aye.
Ms. Spector-Morgan.
Aye.
Mr. Monahan.
Aye.
Mr. Wallner.
Aye.
And the vote is unanimous. I also vote aye. The variance is granted. And that concludes our discussion of 4320 this evening and moves us to the next case, which is case 4520. Warren and Lucille Rund. Applicant requests an equitable waiver of dimensional regulations under RSA 673-33A to grant legal status to a 6-foot tall stockade-style fence located on the southerly side, property line between the front lot line and the front yard building setback line for property located at 168 South Street in an RS residential single-family district. Is either Warren or Lucille Rund here to chat with us this evening? Ah, yes, I see they are.
Yep. So this is Kelly Ovid Puck. I represent the Rundys, and I have with me today both Warren and Lucille.
And I apologize for mispronouncing their name.
No, not a problem.
What would you like us to know?
So I think this is pretty straightforward. We've laid out what happened, I think, fairly clearly in the application. So I'm just going to give you a brief summary. The Rundys are on South Street. They had an existing 6-foot high fence. As a result of the maple that's there on the corner, that's actually on the abutters property, that's an invasive maple. They really wanted to kind of block that a little bit more than they previously had, so they decided they wanted to extend the fence. They were concerned about complying with the city's requirements, so they reached out to code enforcement and spoke with a staff member there and said, we have an existing 6-foot high fence that runs up the side of our property. It's the south side. You can see it here on this picture that Craig has pulled up. And we'd like to know if we can extend that fence up to the property line, or how far can we extend it up? And they were told that it was allowed an 8-foot fence on the side, and their fence was only 6 foot, so they could extend it up to the sidewalk. After that, then they had a staff member from city engineering actually come out to the property and talked with that staff member about what they plan to do, and were again told the same thing, that they could extend the existing 6-foot high fence up to basically the property line. And Craig, if you want to put up one of the pictures that show, I think a little bit closer, you can see where the fence has actually been extended to. I think that prior picture was the existing fence. So here we have, and this is Lucille here, who's standing in about the place where now the city, the code inspector has said it's only allowed to be a 4-foot high fence. So, and I think the issue of confusion is that the ordinance says a 4-foot high fence is allowed in the front yard and an 8-foot high fence is allowed in the side yard. But the question is, you know, on this corner where it overlaps, is that the side yard, is that the front yard? How is that applied and interpreted? And so that was why my clients sought guidance from the city and did what they did. They relied on that guidance and they built the fence. And then very shortly after the fence was completed, the code inspector came out and advised them by letter the following day that that violated the city ordinance. So it's going to cost my clients over $2,700 to take down the non-compliant fence and reconstruct the fence in compliance. And so we're asking for an equitable waiver from the requirement that the fence only be 4 feet high in the front yard.
Is where the person is standing there, is that where the setback is?
Yes.
Okay.
So I guess it's not technically relevant because no one's arguing that you're within that you can do this. But I just want to make sure I understand that this fence separates this house from that house south on South Street, right? So
yeah, 172. Yep.
So which part is it? Because if the fence goes too close to South Street, it starts to become into what's considered the front yard?
That's the interpretation, yes.
But you're not disputing the interpretation.
Well, at this point, we're not disputing the interpretation. We're asking for an equitable waiver because my clients relied on the city's interpretation, whether, which interpretation is right is maybe an issue, but that's not what we're arguing today.
Okay. Oh, I see. So at some point it becomes the front yard as it gets past where the house is.
Sure. Well, and I guess it's not clear is at that point, is there still a side yard there? They looked around and I included in our supplement some pictures of other fences that are similar to this fence that kind of go all the way up to the property line, but they're kind of running along the side of the property as opposed to facing the street, which kind of made sense to us that it's facing the street. And that's what the city staff members had said. If it was facing the street, then it needed to be the shorter height of 4 feet. But if it was running up the side, then they were fine to go with the height that was required in the side yard.
Gotcha. Okay.
So.
Other questions from the board? Ms. Ovett-Puck, did you have anything else you wanted us to hear?
I don't think so. I mean, I think there's some arguments in our application about why we don't think this diminishes the value at all of the abutting properties. And you can see aesthetically it looks good. I don't really need to elaborate on any of that. I already talked about the cost of correction. I think it's pretty clear that my clients were operating in good faith. They actively reached out to the city. So I think that's really it. Unless anybody on the board has any questions, we're happy to answer them, and we appreciate your time.
I do have a quick question. Is it just what appears to be 3 new fences? Are those the ones?
Panels, yep.
Those 3 panels?
Yes, it's just those 3 panels that were added.
Any other questions?
I have a question. I'm not sure if it's appropriate now or later, but I noticed we got correspondence from the abutter.
Yes, I have a letter which I'll read.
Okay, so and I'd like her to respond to that whenever the appropriate time is.
Yep, we can certainly do that. Any other questions from the board?
No.
All right. Is there anyone who'd like to be heard in favor of this appeal? Is there anyone who would like to be heard in opposition to it?
Yes.
Mr. Burbank?
Yes, this is Keith Burbank, the abutter at 172 South Street.
May I swear you in, please? Do you swear to tell the truth and nothing but?
Yes, I do.
What would you like us to know, sir?
So as I said, we are the abutter at 172 South Street, so we're on the other side of this fence. This fence is about 15 feet from the property line to our driveway. And obviously, when the fence went up, I immediately called the code office to find out if that was allowable, that height fence, and was told immediately that a fence of that height was not up to code in a front yard. So when I called the city code office, they told me no, it was actually against the code. Beyond that, the biggest issue we have with this fence is that it is a safety issue. Our driveway is located right on the other side of this fence, parallel to it. this neighborhood is, if any of you know this neighborhood, it's a very busy neighborhood as far as foot traffic, bike traffic, actually just car traffic on South Street. And having to back out of our driveway without being able to see to the north side of the street or northerly from our house is very difficult. We cannot see anybody coming down the sidewalk on a bike or on foot until we've backed out practically the entire way to the street. So that would be our, that is probably our biggest issue with this fence. A 4-foot fence, I'm sure we could see over it. That wouldn't be an issue. So a 6-foot fence, it's impossible.
Any questions for Mr. Burbank? Thank you, sir. Is there anyone else who'd like to be heard in opposition to this appeal? I do have Mr. Burbank's letter. It is in the record for anyone who cares to see it. Essentially, it says the same thing as his testimony, so I won't take the trouble to read it right now. Mr. Walker.
Oh, sorry.
No, go ahead.
Sorry, go.
If you're wondering about the rebuttal, I usually let Craig say his piece first.
Sorry.
Right.
Even if I do titter up my sleeve when he does it, but Mr. Walker.
Well, yes. So as far as what may have been told to the applicant, I could neither confirm or deny what may have been asked or what may have been answered. It has been longstanding practice and interpretation, though, that within the front yard area, which would be a space between the street and the a line parallel to the line through the nearest portion of the house, from that point to the street, even including the side lot lines, it cannot exceed 4 feet. Anywhere beyond that area or the standard setback, yes, can go up to 8 feet in height.
Very good. Thank you. With that, we'll
Sorry, Chris,
go back to
Chris,
Ms. Ovenbrook and ask her if she has anything that she would like to, any response to the information that she just heard.
Certainly. So we did submit some pictures so that you could see the effect on the visibility. And I think you'll see there's actually, from the street, there's actually a strip of grass and then the sidewalk. And then our clients did not even build the fence all the way up to the property line, which they could do. And if they're required to reduce it to 4 feet, they probably will do. And you can see there is that large, the maple there that blocks a lot of visibility already. So we don't think that the additional 2 feet, it really has that much of an impact.
If, what would be your client's reaction to request to take out one section closest to the street and replace it with a 4-foot section?
Take out one section, but we probably extend it to the sidewalk then, which, if we take the 6-foot section, the last section, cut it down to 4 feet, we probably even use that material to continue it to the sidewalk. We left enough space there so people could see around there. If you take the view looking down from the Burbank's property, if you visualize, there's one little spot there where there's a green flag there. That's the 4-foot section, and their tree is blocking most of that, and it would end up being blocking. It would block. It seems as though it would end up blocking more if I extended it to the sidewalk. It just seems, if you look at the pictures, you can see what's blocked from their driveway anyway by the trees on their property.
Chris, I have a question for the applicant, if that's okay.
You bet.
So I think the application does a pretty good job and explained well the confusion over the direction they get from the city, but what I haven't heard from the applicant, maybe I missed it, is what are they trying to accomplish with the fence?
Part of, as I said earlier, that that maple there, which is the Norway maple, is an invasive prohibited species. So part of it is they're trying to mitigate some of what's coming over onto their yard, which they can't do all the way. That, I mean, it's a tall maple, but at least prevent some of like the leaves that we used to blow on their yard from coming over, as well as just give them a little bit more privacy. I mean, it is the neighbor stated the driveway is right there. It's pretty close, so.
Sorry, the maple is on the neighbor's side.
Yes.
So.
Yep. Yeah. So.
Somebody was trying to get my attention.
When you
Mr.
say,
Burbank. Sorry, Mr. Burbank has his hand up again.
Oh, Mr. Burbank. Typically, we don't allow double testimony from people in the audience. So I think we have heard what you have to say. We do have the pictures.
Okay.
I don't think we're going to extend the testimony any further in this particular situation. Thank you. Any other questions from the board? Where were we? We got to Craig and then rebuttal, right?
I have a question for Craig, for Craig. So, because I'm looking at the letter from Mr. Nato, and he, with regard to the alleged misunderstanding, he had similar language to what you said tonight, something like he can't comment on it. But one of the, the applicant has alleged that they received an incorrect interpretation from a municipal officer. At least from what they've alleged, it seems that they're alleging they meet that criteria, which is one of the criteria we have to find. Does the city take a position, or does the city want to offer any contradicting evidence to what they've said, or?
Well, Andrew, if they could identify who they talked to, we could bring that individual in and have an explanation on what was discussed, but they have not identified who they have talked to, so I can't present anybody of that nature, I'm afraid.
I thought they did.
I think they did.
They said,
we do. We identify both individuals we're communicated with.
I'm sorry, I missed that. Where is that?
In the application, I think.
And who did you state that you talked to?
Rose Fife and Paul Gendron.
Okay, well, Paul Gendron is a city surveyor, and he would have no jurisdiction on defining fence height. Rose Fife, boy, Rose has been with the office.
Craig?
Yes.
If you'd like, I can speak for myself on this.
I'm sorry. Rose is present.
That's fine. I don't usually talk at these meetings, so I've been very quiet, but.
Do you promise to tell the truth and nothing but the truth, Rose?
Absolutely. Absolutely.
Right.
I recall the conversation with the gentleman, and I spent an enormous amount of time with him trying to explain, and fencing regulations are very difficult to explain, but I thought I had gotten through that where the home ends at the, see, even now trying to explain it to you is a little bit difficult, but the front yard is considered the front of their house back to the portion where their house begins. That's all front yard, and that can only be 4 feet. I thought he understood that when I explained it because we did spend so much time, but apparently I didn't get it through the way I thought I did. So I think this was just a complete misunderstanding of information.
Thank you, Rose.
Yep.
I mean, sorry if I could, Craig. I understand your point that Paul Gendron has no jurisdiction, but technically, technically, if it's a statement from a municipal officer, even if they went beyond what they should have, I guess there's no way to know. No one's talked to Paul about what his side of the story would be about this.
No, if you'd like to request him to come in as a witness, we can make him available.
Why don't we close the public testimony portion of the hearing, and then we can continue to talk about these issues. It is so. The public testimony portion is closed. Andrew, did you want to continue with that line of thinking?
Well,
You pretty well said what you need to say.
No, yeah, just one more thought on that. I think we need to look personally. It may be irrelevant. We might look at the last criteria, which is the cost of correction outweighs the public benefit. Obviously, that even if they're right about what they claim that they were told, they still might not get the equitable waiver if we find that. But if we don't, I do think if we think they meet the other criteria, then they state point blank that Paul Gendron inspected the property and confirmed the fence could be extended to the front property line. I think what Craig's suggesting is Paul wouldn't say that in those words because that's beyond his expertise. But we don't, without hearing from Paul directly, I can't say that the applicant is wrong or I couldn't weigh credibility on that. So if we otherwise deny it because of they don't meet the criteria anyway, then it's irrelevant. But if that's the one sticking point, then I kind of do think we would need to hear from Paul.
One of the criteria has to do with safety, I believe.
Well, the last, it doesn't specifically say safety, but I think it would include it. It says the cost of correction so far outweighs any public benefit to be gained, which obviously public benefit would include safety. So if we think the cost of correction does not outweigh if there's a safety concern for traffic, I don't think personally the cost of correction is gonna outweigh that.
But I think Chris is looking at third criteria, which is that the violation does not constitute a public or private nuisance, which would be a safety.
Oh, yeah, yep.
Nor interfere with abuse affect any present permitted. Yeah. I guess for some reason I thought the word safety was floating around in there, but I guess it isn't. Okay. Nick, what do you think?
I like your idea, Chris. Lower one fence section, but I don't know if we can really do that, can we?
I'm not sure that we can. Craig, do we pretty much have to either grant or not grant here?
I think you can have a little flexibility on this one. You could deny or grant the 6-foot height up to within 10 feet of the front property line, perhaps, and then they would have to comply from that point forward.
It just seems like a give and take for both parties. Everybody would gain something from it, not 100% of what both parties hope for.
Jim, what do you think?
Yeah, it's tricky for us trying to negotiate a resolution in this format, but I don't disagree with that as a solution. But I also heard the applicant suggest that if they had to lower the height, they might extend it to the property line.
They did say that, yeah.
Yeah, and that creates I don't know what's worse from the abutter's ability to see what's coming when they're backing out of the driveway. So,
good point. Ms. Beckner-Morgan, what do you think?
I'm going to go out of my normal shell here and say I think we should grant the equitable waiver. They made a good faith effort to figure out what the rules were. Sounds like they misunderstood, like it was a good faith misunderstanding. And the regulation's not necessarily clear. I hear what the neighbors are saying, but looking at where the fence ends and how much space there is between where the fence ends and where the traveled way begins, I'm not seeing that safety issue. And I'm not sure whether they said $2,700 or $2,900 to fix this, but that's not insubstantial. So I would grant the equitable waiver.
Mr. Winters.
So we would have to find not just the misunderstanding, but that an error in ordinance interpretation or applicability made by a municipal officer in the process of issuing a permit over which that official had authority.
That's the way it's written.
I mean, the city is definitely denying that. And now that I've read it again, I think Craig's point is more well taken, which is that I don't, that Paul Drennan doesn't even have authority over this issue. Now Rose does, but she's defending, she's admitted, she's acknowledging that it's a little confusing, but she's definitely not stating she made a misinterpretation.
But do we issue permits for fences?
No, I was just going to pop in and advise you that no, we do not issue permits, nor do we require plans or anything of that nature for fences.
So why do you think Paul was even out there?
I believe he was helping them to identify the front property line would be my guess. That's generally as far as Paul will go as a city surveyor.
Okay.
May I add something in here?
Please.
Normally when someone comes into the office and they're trying to do something in their front yard area, I suggest to them that maybe they should speak with Mr. Gendron so that he could flag out where their city right-of-way ends, because normally people don't know where their front property line is when there's a sidewalk involved. So normally I'll ask them to speak to him, because he does do that as a courtesy to go out and do that. So perhaps that's where he came into play.
Got it. I feel somewhat ambivalent about this one. I think someone who goes to City Hall and asks for advice on this and misunderstands what he is told or she is told, if it's an honest misunderstanding, to me that's a pretty close cousin to a honest error in a measurement or that sort of thing. I don't doubt, and I also don't think that, even though the ordinance does call for the inspector to have jurisdiction, I don't know that a ordinary citizen would know who had jurisdiction over what when encountering that. So it could still be an honest error on their part, misunderstanding. It sounds like Ms. Fife went to some trouble to try and explain the situation, and for whatever reason that the message didn't get through. We've all had that experience trying to explain something to someone and just not being able to do it. On the other hand, all of which would argue in favor of, in my mind, even though it's a sort of an elastic interpretation of granting, on the other hand, I look at that fence and I do see how that could be a problem. If you're in an automobile backing out of the driveway, by the time the driver can see around that fence, the back of your car is probably out on the sidewalk.
Certainly if it's a minivan, for sure.
Well, yeah, a minivan you might be able to see over, but I don't know, not a 6 foot, I guess. So, and the idea that the fence would go out to we talked about the revision in the design. Although I think that's a plausible solution, I'm not sure we ought to be redesigning the fence, even though we might theoretically have the power to do so, especially since the owner is now talking about if we lower it, extending it, which becomes, now we've gotten involved in sort of a 2-level change in the design, and I don't think that's something we want to do. So I guess because of the safety issue, I do think it creates, it does interfere with the use of the property. Again, it's not a literal interpretation of the statute. It doesn't really seem to offer us a chance to interpret it literally, other than to read it the way Andrew does, which is to say it's the person who gave this advice wasn't necessarily authorized to do it, and that whatever advice it was he gave, and we don't really know, and then the other person that we can talk to, Ms. Fife, has made it quite clear that she did not intend to convey that message and didn't think she had. So I guess with all of that, I'd be inclined to deny, having way overrun my time period for comment here. Does anyone care to make a motion in either direction?
Well, I'd move to deny, and just looking at it again, to repeating only because we don't see this very often. It says a person in the process of issuing a permit. They're not even claiming there was a permit. So nobody was ever issuing a permit. So I moved to deny.
Okay.
I don't think they've met that standard of having bad information from a municipal officer.
Is there anyone who cares to second that motion?
I'll second it.
Been moved and seconded. Discussion.
Yeah, I'm not going to support it. I'm trying to, I'm looking at this practically. I think a 4-foot fence out to the property line is a worse situation than what exists now. So I think the practical way to get there would be to perhaps proceed the way that Laura has suggested, that we grant the equitable waiver.
I guess my reaction to the question of issuing a permit, to me, that's a technicality that the owner operating in good faith doesn't necessarily know that little fig leaf is in there. He thinks he's talking to a city official, and the city official gives him direction, and away he goes. So I don't know that I would buy that, but I do have concerns about the safety side of things, and that's, I guess, still where I'm coming down on it. Laura, what do you think?
I stand by what I said earlier. I would grant the equitable waiver, so I'll vote against the motion.
All right. Well, let's call for a vote then. All in favor? Mr. Wallner?
Aye.
Mr. Monahan?
No.
Ms. Spector-Morgan?
Yeah.
Mr. Winters?
Aye.
And I also vote aye. So it's a 3-2 vote with Mr. Monahan and Ms. Spector-Morgan in the minority. The request for a equitable waiver is denied. And I think that concludes our regular agenda this evening. We got some minutes, didn't we, Rose?
Yes, we have September minutes, but I think the July minutes are still being worked on.
Okay.
July are still lacking. They're finished. I guess I must not have gotten them out to you.
I didn't see them, and I went to the website, didn't see them. I just saw the synopsis and the final decision on each case for July.
Okay, thank you.
So move approval on the September minutes.
Is there a second? Oh, come on, guys.
I'm going to abstain because I wasn't there.
I second.
Okay. It's been moved and seconded. All in favor?
Aye.
Aye.
Anyone opposed? The vote is unanimous with one abstention. Any other business to come before us this evening? Craig?
Nothing that I have prepared, so no.
All right, then I guess we can pack up our picnic baskets and go home.
It's showtime on.
Yeah.
Just in time. Well done, everyone.
If you like that kind of show, yes.
And our next meeting's November 4th. That's going to be interesting.
Day after the election, yeah. And I'm ward clerk, and I'll probably be working 16 hours that day. So.
Well,
you'll be working 16 hours.
I just sneeze when I come in to vote.
Thank you, everyone. Good to see you.
Thank you all very much.
Thank you. Bye.